Tell them when I'm putting them on my plate. I was like, well, I'll regret this later.
That's so fun.
Then they do that with.
Oh, I know, right?
It's what we're thinking, you know, during that one. Forgot it. Because we're gonna do the challenge. You're with Cassie though. Awesome, very good. Cassie and I have both shared the same boss in the past, but we never looked, but we know each other. So it's kind of a weird little connection there. So.
Okay.
How long have you been with Callie? 7 months. Oh, a little bit newer than that.
I had a career for plumbing stuff. Everything goes down.
For you, that's awesome. How you liking it so far?
Yeah.
Yeah. For like a career change. Yeah.
Yeah.
Absolutely. Good for you. Never too late to try something new. I know.
At the time, I didn't have the option of just going out to another, even though I would offer. I needed the FMLA, which you can't get, so after you're with somebody for a year.
Yep, exactly.
Yep, going back to school. Yeah.
Very good. Awesome.
And I was a supervisor. So HR.
You already got some of those skills that you need. Yep.
And last place, because of the supervisor, in the mornings, all of this stuff. They just sort of.
You already have good foundation. Yeah. Wonderful. Very good.
Yeah.
We're gonna have a soup collision here.
I'm not like the typical levy.
I'm at Riverbank. This is my coworker Becky. We're both business partners over there. And I came from manufacturing. And I've just been in Riverbank for like 2.5 months. So still very new, but we're a pretty good team. If I don't say, you don't mind me saying.
Yeah, please do.
No, it's been really good.
Kind of manufacturing where you want to.
When someone else or like has. So that's manufacturing, printing, finding and distribution across the world. So
I think
Today.
I have our old HR ladies went there years ago. From the place where I work.
Uh-huh. Do you remember her name?
Not off the top of my
Yeah.
So we're hoping.
So March
That was probably.
Okay.
I'm just gonna talk. September 2026 board, and we do have 2 board positions open right now, government and diversity affairs and programming, if you're interested in getting involved. An easy year to do so, since programming is already done by the Grace Taylor, but an opportunity to learn. We have 2 new members, Mackenzie Haugen from Riverbank and Sarah Jar from Schilling Supply Company are either here. Who do we have in the back?
Mackenzie from
Welcome,
Riverbank.
Mackenzie. And then another thing, for annual sponsor, there's the Insurance Center, Express Employment, the Alliance, and Trust Point. We do have more opportunities if your company would like to sponsor in any of those categories. And then coming up, our meeting in April is on building a grief inclusive workplace and strategies for HR leaders. And then May is on future ready leadership. We have our meetings filled out. We can scan QR codes to go to the website to register for those. And like I said, join us next month for building a grief inclusive workplace. Yep. And then on April 22nd, we are having our coffee chat at the Grind and Settlement. If you want to come, coffee is on the LASHRM and connect a network of other professionals in the area. And then before I open it up to additional announcements, just a reminder to give your name tag back at the check-in table before you leave. We use it to register you when you come to each meeting, so please don't take the name tag home with you. Any announcements from anyone in the room? Okay, we're chugging along. So today's presentation is the HR legal update with Storm Larson from Boardman and Clark. Storm is an employment law attorney. He litigates on behalf of his clients, well loved by Ultra. He doesn't litigate for us often, but he's a good help when we need him. And he's gonna give us a legal update, so help me in welcoming Storm.
Thanks for figuring out the mic.
You're welcome.
All right, so it's good to be back with all of you. Again, I gave this presentation to you all last March, and I'm telling my legal assistant when I get back from Madison in Milwaukee that she can just stop calendaring this for me. I'm just gonna wait till the worst snowstorm of the season. And say it's time to go look across for the HR. So I'm glad you were all able to make it safely. I came in last night before the snow kind of hit overnight, so all good and well. So, and I'm really excited about today's presentation in particular because it's the only material. I put this presentation together specifically based on everything that has not been presented to other organizations yet. So you guys are kind of getting the first look at the new updates for 2025 and 2026. So I'm really excited to talk about some new stuff that hasn't really hit the other organizations yet. And since you're all eating and the food comment hasn't hit you yet, I thought I'd start with wage and hour. So like, I'm not gonna bury this in the middle or towards the end when we're all done from. There have been a few updates in the area of wage and hour, and I just want to highlight a couple of them. We've gotten some new opinion letters from the Department of Labor, and if you're not familiar with what an opinion letter is, it's a statement by the Department of Labor interpreting laws like the FLSA, the FMLA, different laws that the Department of Labor enforces. Why opinion letters are really important is it's because the Department of Labor is giving you an opinion based on specific facts that an individual has written to the DOL about. So if you have a question about how an FLSA regulation might be interpreted, how the Department of Labor might interpret the FMLA on a particular issue, you can write to them. It's pretty expensive and sometimes cost prohibitive for smaller organizations to do that. But when the Department of Labor gets a request for an opinion letter, it issues a public letter that all of us get to read for free. So when these come out, especially on, issues that are a little bit murky and we're not quite sure what the response is, these are a really helpful way to guide HR audiences on what the DOL's position is. So the first one that I want to talk to you about concerns the FMLA. And for those of you who are not FMLA covered, don't worry. I'm going to get to you towards the end of the presentation about leave accommodations. So if you're not FMLA covered, this is probably not as much relevant to you, but if you are, this is an important thing to take note of. So the first one that it's titled FMLA 2026-2. So it's the second opinion letter that we've gotten from the DOL this year. And this one concerned travel time to medical appointments. So as you know, when an individual requests FMLA leave, they can take it on a continuous basis or on an intermittent basis. And it can be sometimes hard to track, especially for individuals who are taking on a reduced leave schedule or on an intermittent basis to figure out when are they going to be taking this leave, for how long, what are the increments, why are they taking it? It can sometimes be hard to administratively track. It also can be hard to track when an individual has to take, say, their father or their child to a medical appointment for a serious health condition, or even travel a significant distance to take their own self to an appointment for a qualifying condition. What do you do about that travel time? Well, the DOL issued this opinion letter and states that the time spent traveling to an appointment is covered as FMLA time. So not only is the duration of the medical appointment covered as FMLA under an intermittent or reduced schedule leave, the time spent driving. So say if you're in La Crosse and you have to go to the Toma Clinic, it can be quite a ways away to get there. That time spent traveling, 40 to 45 minutes, that's going to be covered as FMLA leave according to the Department of Labor. So it's important to keep in mind too, the administrability of intermittent leave. It's hard to track. So staying on top of an individual and having them know where to be entering their FMLA time is really key. Make sure that you have that entered in the system somewhere and you're staying on top of that individual to make sure that whatever time they're taking does or does not qualify for FMLA. If they're just sick one day, or if they have a childcare issue, not going to be FMLA. So making sure that you're staying on top of the time that they're spending traveling and the time spent actually at the appointment. The next opinion letter that we got from them concerns the FLSA, so Fair Labor Standards Act. A common issue that comes up is how you classify a bonus that an individual gets. So as you know, for individuals who are hourly non-exempt, if they get a non-discretionary bonus throughout the year, that bonus then has to be factored into their regular rate of pay for calculating overtime. This is something that can sometimes get tricky, especially if a bonus isn't calculated or earned until a certain point. Then there are allocation metrics that you can use to try and calculate that regular rate of pay over that period of time. But staying on top of your HR manuals that define what a bonus is and how it's calculated is going to be really important. Because as you know, non-discretionary bonuses factor into overtime pay. Truly discretionary bonuses do not. This opinion letter was helpful because it just reaffirmed what the DOL's position is on what qualifies as a discretionary bonus and thus not subject to overtime calculations. I think we, is there a point here? Oh God. There's something. I'm the side of okay. So you'll know that the bonus is discretionary. If it is in fact, the amount of the payment must be determined at the sole discretion of the employer. The employer's determination must occur at or near the end of the period when the employee's work was performed, and the payment must not be made pursuant to any prior contract or agreement. So think of it as at the end of the year, you have a Christmas bonus or a holiday bonus to reflect performance at the end of the year. If that is just something that is based solely upon the company's determination of how that individual performed, and there's no promise or guarantee to that employee that they will be getting that bonus, then it's discretionary, right? So just important to keep that in mind when you're calculating overtime. And it's especially important with the hourly non-exempt individuals that you've got. Okay. So this is another FLSA issue and it qualifies, concerns the learned professional exemption. So as you know, just sort of FLSA 101, you have to meet the salary basis test, the salary amount, and the duties test to qualify as an exempt individual under the FLSA. This opinion letter discussed what happens if an employer, for whatever reason, wants to take someone who was previously classified as salary exempt under the learned professional exemption. It's one of those 3 white collar exemptions that we're all familiar with. If someone wants to change the duties of an individual to destroy the duties test, so that individual no longer meets the duties test, but they also want to change them to an hourly employee, does that individual still qualify as exempt? So remember, you have to be paid on a salary basis, you have to earn the salary level amount, and you have to perform, you have to meet the duties test. You can change an individual to an hourly employee and also change their duties, and it would still make them non-exempt so long as they're not meeting those 3 criteria. Just a helpful reminder for how the DOL is thinking about these things, and that each of those 3 factors have to be met at the end of the day for someone to not qualify for overtime. All right. I have the word proposed up here in red, and PowerPoint wouldn't let me do like a flashing lights feature. So I just want to draw your attention to the fact that this is proposed. There have been no changes on this yet. This is all just tentative. The DOL is still taking comments on whether this would be a good idea. The DOL is thinking about changing the rule for who qualifies as an independent contractor under the FLSA and the FMLA. Independent contractor is one of those things that gives me heartburn because a lot of times employers think that they're using independent contractors or they have used an agreement in the past that qualifies as independent contractor. The law on this changes, so, and it's really hard to meet because just because an individual qualifies as an independent contractor, say under the FLSA or the FMLA, doesn't mean that they qualify under Wisconsin State Workers' Compensation Law. There's all different kinds of laws that have their own independent contractor test. So just because an individual qualifies under one, doesn't mean they qualify under the other. This proposed rule would impact just federal law, FLSA and FMLA. The proposed rule would change the current rule, if it's adopted, to look at the key question on whether someone is economically dependent upon their employer to qualify as an employee. There's many different factors that are currently used to determine whether someone is an independent contractor or not. This would return the question to sort of a simpler test to look at the economic reality of the situation. So whether someone is dependent on their employer for wages on an ongoing basis makes them probably look more like an employee. Because as we know, an independent contractor is in business for themselves. They get contracted to do a discrete task for the employer, and usually they're done after completing that task. By contrast, you're employing individuals in an employee capacity, for an indefinite period of time for an at-will individual. So just keeping in mind that this is a proposed rule, it would change the analysis a little bit on how we would factor in the economic reality for an independent contractor. We have until April 28th for the Department of Labor to keep accepting comments on this, so we won't be seeing any changes immediately, but in the near future, if it chooses to adopt this, there will be a red flashing light on the next presentation that says this is the current state of the law next time. So. Did I push something?
I probably did, but,
Oh, okay. Okay, cool, thanks. All right, any questions so far? And I got some hypothetical examples too, so that I can take a Diet Coke break, like halfway through this, and have some hypotheticals that discussion based on the trustee involved too. So, any questions so far? All right. There have been a few paid leave updates, none really specific to Wisconsin, but as you know, across borders Minnesota, and a lot of you have employees based in Minnesota and have families out there. And in Illinois too, so nothing Wisconsin specific based, but just want to bring a few items to your attention. So in our neighboring states, we have the Minnesota Paid Family Leave Law that went into effect on January 1 of 2026. If you don't have employees based in Minnesota or you're not operating in Minnesota, you don't have to worry about this. But if you are out there, you will likely have been very familiar with these obligations under this law and all the changes, but just want to draw your attention to that because sometimes as businesses expand, it's good to know about what that state's obligations are and what you would be responsible for as an employer, because this law applies to basically every employer in the state. Illinois also passed a new NICU leave law, which is notable for a couple of reasons. It provides paid leave to individuals who need time off to take care of an infant who is in the NICU unit at a hospital or clinic. This law is notable because it specifically does not run concurrently with FMLA, which a lot of paid leave laws do to make it easier to administer for employers and kind of reduce the burden on them. But this law specifically does not run concurrently with FMLA. We issued HR heads up on this topic and wrote an article. If you want some of those articles, I have them over here. We'll sign up for our newsletters that we can provide you for free. We stay on top of this stuff for you guys. So Just a couple of notable laws from our neighbors to the west and to the south. Oh, did it again. All right, so since the new administration took effect, there have been quite a few updates at the EEOC. As you've probably seen in the news, DE&I has been a hot topic on a lot of people's minds, and it's come under really intense scrutiny at the EEOC and at the federal level. There have been other updates as well, and so I built in a specific block of my presentation just dedicated to what the feds are doing with respect to employment laws. Okay. You may have heard about this, but it's fairly recent. The EEOC recently rescinded guidance. The EEOC recently rescinded some guidance that had been issued back in 2024 as it relates to anti-harassment. The vote was 2-1 to rescind that harassment guidance. That harassment guidance was really comprehensive and had been some of the most detailed guidance that we had received from the federal government on the issue of anti-harassment in quite a few years. The EEOC rescinded that though when the Trump administration took effect, said that we didn't like some of the things that were in there, so we're taking that back out. It's important to note though that the core principles of anti-harassment are the same. Right, this does not change any of the substantive law as it relates to sexual harassment, hostile work environment, supervisor liability, all of that stuff still remains the same. The basis for rescinding that harassment was that it talked pretty extensively about gender identity and some issues related to DE&I. So you know that was a campaign issue on the 2024 election, and when the Trump administration took effect, they made good on that and rescinded that guidance that had addressed those issues. But the core issues related to anti-harassment, all of the laws are still the same. Just some of the nuances that had explained, you know, when gender identity harassment occurs, those were the sorts of things that they wanted to revoke. Likely though, you can still state a claim for gender identity harassment because the substantive law hasn't changed. You know, the executive branch can't change what the legislative branch has enacted into law, but they can sort of reprioritize the types of claims that the EEOC is going to be looking most closely at. So this is more just kind of for your general background knowledge to understand that's the temperature that we have right now at the EEOC and the sort of things that they're looking at most closely. And the EEOC actually put out a statement when they rescinded the guidance to say that all of the anti-discrimination protections remain in effect, so we shouldn't be thinking really any differently about our policies as it relates to training supervisors on creating harmonious work environments, that sort of stuff. All right. This one was really interesting to me. The EEOC brought a sex discrimination lawsuit on behalf of a group of men against Coca-Cola out in the Northeast. So Coca-Cola had decided that it was going to offer a group of female employees a sort of retreat at a casino resort to build workplace harmony, you know, train them, just see what was going on with if there's opportunities for advancement with these individuals. They didn't offer the opportunity to any men. So the EEOC saw that and said, we think that this is sex discrimination on behalf of these male employees because they were all excluded from this opportunity on the basis of their sex. The case is pending, and I checked this before I came. Coca-Cola has not yet answered the complaint brought by the EEOC. Their answer is due on April 21st, 2026. I don't know what they're going to admit, what they're going to deny, but it is pretty significant when the EEOC decides to be the named plaintiff in a case, because that brings all the power of the federal government behind them, all of those resources. So when they take on a case on behalf of plaintiffs, it's a pretty big deal. And they must think that they have a pretty good shot of proving their case. Otherwise, they probably wouldn't be bringing it. So practical takeaways for you guys though, is Opportunities afforded exclusively to underrepresented classes are receiving increased scrutiny. This is just kind of in keeping with the kind of the skepticism over DE&I that we have. This kind of dovetails with that a little bit. But it's interesting though to see that litigation is actually pending on an issue like this. Because I'm sure Coca-Cola thought that it'd be great to advance some females up through the organization, develop them. But at the expense of male employees being excluded, looks like it might qualify as sex discrimination. So, it's interesting. One of my favorite cases, and this is a public accommodations one, and it's not listed here, was that a ladies drink free night was held to be sex discrimination in public accommodation. A bar was offering free drinks to just women. So that's just interesting to me. I always see that in the digest when I'm reading through it. I'm doing my research. That was under state law though. Oh, what was that?
I kind of like a senior I have ladies sign on Wednesdays to get buy one, get one margaritas. If you're a woman.
Where is that?
Yeah. Don't report that.
I never went there.
So, we're having. If I can was buy one, get one, you give it to me, that's great. All right, so the EEOC also, and this is an open letter that the EEOC penned an open letter to Fortune 500 companies, and you can actually go download it. It's available online. I didn't cut and paste it here because that would be too much to read. But on February 26th, so just a few days ago, the EEOC's chairperson sent an open letter to several hundred Fortune 500 employers, reminding them of their obligations to comply with anti-discrimination laws, and reminded them that DE&I programs may constitute unlawful discrimination, regardless of whether they are designed to help underrepresented populations. So again, this is just sending a not so gentle reminder to the Fortune 500 companies that we're watching you. And I think even the EOC has an online portal where you can report practices that you think qualify as, DE&I discrimination. So just being on the lookout for those types of things is a good thing, because these Fortune 500 companies have the resources to fight some of these things and to really, put their back behind the programs that they've implemented. But for smaller companies, it can be more of a burden to respond to, complaints and inquiries from the EEOC about what's happening. Case law updates. Any questions so far about any of this? Case law update. So these are all brand new cases that have just come out, and they're an interesting reminder about how courts are currently thinking about several of these issues that come up pretty frequently. The first one is Chitwood versus Ascension Health Alliance, and this actually came out, I think, just a couple of weeks ago. It was really interesting to me because it dealt with an FMLA retaliation and intermittent leave issue. So every one of these cases kind of starts out the same way. There's an individual who applies for FMLA, everything's going great until some performance problem happens, or they don't like something that happens to them, and it then gets attributed to their FMLA leave. So Elizabeth Chitwood worked as an HR specialist at Ascension, and she requested FMLA in 2021. She was approved for intermittent FMLA and continuous leave, which was set to expire on November 3rd of 2021. When her leave expired, she didn't return to work, and she wasn't responding to several messages from Ascension about returning back to her job. Ascension demanded that she return back on November 15th of 2021. She applied for a personal leave of absence on November 4th, which would have taken her through December 1st of 21, but Ascension denied that request. So some of the timing here is important. So her leave was set to expire on November 3rd, and the day after her leave was set to expire, she applied for personal leave of absence the day after. That would have taken her through about another month. Her unresponsiveness to the company's request for her to return back proved to be pretty critical in this case, because remember, an employee who's not responding and cooperating through FMLA leave runs the risk of having the employer discipline them for not complying with leave procedures and notification policies. So the fact that she wasn't responding to this ended up being a pretty critical fact. She didn't do herself any favors otherwise by logging onto her computer on November 15th, said she couldn't get in, who knows how hard she actually tried, and then sent a vague voicemail implying that she assumed that she had been terminated simply because she couldn't get into her computer system. Essentially took her up on that and said, okay, if this is a resignation, we're gonna terminate you, which they did. They terminated her that same day after getting that message. This is a pretty aggressive approach on staying on top of this individual. And it sounds like Ascension had their ducks in a row and understood the timeline really well in this, because the court ended up rejecting the employee's claim for FMLA interference and retaliation, because she had tried to retroactively designate some of her absences after she was terminated as FMLA protected. So remember, you can sometimes retroactively designate absences as FMLA protected, but she had already been terminated at that point, and asking to have that happen after her termination, the court said, no, we're not going to do that because you had been terminated, and we view this basically as an attempt by you to muddy the waters on this issue. So staying on top of the timeline is really important, because you can get yourself out of hot water by really staying on top of employees and managing this well. So this reminder, as a key takeaway, retroactive FMLA designations aren't required after an employee has been terminated for reasons unrelated to FMLA usage. And failing to return to work and abiding by an employer's attendance policy can be a valid reason for termination. Because remember, you can always terminate an individual, even if they're on FMLA, for a reason that is unrelated to their FMLA usage. So just a helpful reminder. All right. How am I doing on time? I don't have
Can you
to.
go back to the last statement that you had at the bottom and speak to
Yeah.
that a little bit, where it says, however, be very careful about offering additional leave beyond FMLA in regards to accommodations, that's a slippery hill.
I missed that, yes. So when I gave that warning to folks who aren't FMLA covered at the beginning, this is kind of your time to shine. So remember that even if you're not covered by FMLA, sometimes a leave of absence can be required as a reasonable accommodation under state and federal disability laws. State law is much more friendly than federal law is. I have seen courts and agencies approve leaves of absence up to 12 months as a reasonable accommodation for a disabled employee. Remember though, you do not have to provide that 12-month leave of absence or any leave if it qualifies as an undue hardship on your organization. It's important to consult with legal counsel though, to make sure that you have your ducks in a row on what truly qualifies as an undue hardship, because just because you say it doesn't necessarily make it true. You have to have done that analysis on the front end to say, here's why this 12-month leave of absence would be a hardship on us. This is a key employee. They are required to be in the office for this sensitive work. They are the only person that we have who has this knowledge. They're a customer-facing individual. We can't have them out that long. It's our busy season. There's a whole host of different reasons why an extended leave of absence wouldn't qualify as a reasonable accommodation. Just make sure you've done that analysis, because those are the sorts of things that I walk through with HR folks. So. And remember too, the definition of a serious health condition is sometimes different from a disability. So there's a bunch of different moving parts in here. So say that an individual has an overnight knee surgery, right? So that would be a serious health condition. They have an overnight stay in the hospital. A knee surgery is not going to qualify as a disability. So just remember that the definitions differ, and you don't necessarily have to accommodate every condition. Go through those sort of analytical steps to make sure that you're denying and approving only what you have to. Did that kind of cover that? Thanks for catching that oversight. All right. How am I doing that time?
40 minutes.
40 minutes left?
Yep.
Okay, cool. All right. The next case that I have for you, another new one from 2025 that I haven't presented to you guys on yet, is Lane versus Stericycle. This is an equal pay case, and the Equal Pay Act is one of those statutes that doesn't come up all that often. it usually arises in the context of like a Title VII sex discrimination claim. So say that, a woman who is doing the same work as her male counterpart is getting paid, substantially less than the males who are doing the same work as her. She could bring a Title VII claim, and she can also bring an Equal Pay Act claim. The Equal Pay Act aspect of this case accrued when Stericycle had reorganized its sales department back in 2021. And as a result, several of the women were paid less than their male counterparts in the same role. After they were promoted, some of the men received pay increases immediately, while some of the women did not. It was only after the women complained about the unequal pay that the company boosted their salaries to the level of their male counterparts. This created a factual dispute that the jury was required to resolve. So this case, I'm gonna get a little nerdy with you just for a second. This case was before the court on what's called a motion for summary judgment. On a motion for summary judgment, the court looks at all of the evidence that has been collected to date. And it's the employer and the employee fighting about what that evidence says. The court is not allowed to resolve key factual disputes. That's for the jury to decide. The court's only job is to look at all of the facts that are agreed upon. Does that qualify as a violation of the law? And if you guys are disagreeing about key facts in the case, that's for the jury. I, the judge, am only qualified to resolve an issue of law that everybody agrees with the facts on. This was a summary judgment. The court said, no employer, I'm not gonna dismiss that case because there were key facts about when the women were complaining and whether the employer would have boosted their pay absent the complaints that those women were making about their pay decreases or their failure to have their pay boosted like their male counterparts. The Equal Pay Act is also interesting for another reason in that an employer can cite as an affirmative defense, so a defense to a claim that a woman says that she's being paid less than a man. The employer can say, it wasn't because of sex. Here's several other reasons. Here's a sex unrelated reason that we decided to have a pay disparity. Like, for example, tenure with the company, length of history. It's perfectly legitimate to pay someone more because they've been with the company longer. You just can't do it based on their sex, right? So having those sex neutral reasons for having salary disparities is an important thing. And documenting why an individual is getting a pay increase for the given year or is not getting a pay increase for the given year is important because when these cases come up, that's the sort of evidence that you're going to want to be able to look at down the road to defend against an Equal Pay Act claim. All right. And I have just listed on there some of the key factors that you can introduce as examples of why an individual might have a different salary than someone else unrelated to sex. For example, tenure with the company, their education level, even their prior salary levels, so long as those prior salary levels themselves weren't discriminatory. So these are fact-intensive things that take a long time to resolve. Right. This one, this case was really interesting because it dealt with current events and dealt with lawyers fighting with each other. So the defendant in this case is a law firm based in Milwaukee, Foley and Lardner, and the plaintiff is an attorney. She sued Foley and Lardner under Title VII, alleging race and religion discrimination after the law firm rescinded her job offer. So just for a little bit of context, when you're in law school, your second summer of law school is really important because you do what's called a summer associate position with a firm. And at the
Hi,
end of that summer
Andrea. This
associate
is
position,
Tabitha
you
from
usually get
Express Employment
offered a
Professionals.
position
I work
the
with
firm upon
Jean.
graduation.
She is
So
on
if you
vacation
did like a really good
this
job with
weekend.
them, they'll give you an offer to join their firm afterwards. The plaintiff in this case was Muslim, and she completed her summer associate position in 2022, and she was offered a position with the firm. A year later, the tragic terrorist attack in Israel happened on October 7th of 2023. I think it's pronounced Shehadeh. Shehadeh shared multiple messages about the attack on social media, condemning colonization and supporting Palestine. So sort of anti-Israel posts she was sharing online. She also went to a Chicago City Council meeting, because the firm was based in Chicago. And she opposed a resolution publicly that was set to denounce the terrorist attack in Israel. So she was making some pretty vocal statements, refusing to condemn the terrorist attack that happened, and also just voicing support for Palestine. The law firm, before she was set to start, Googled her and found these statements that she had posted online and information about the things that she had been saying. The firm was concerned about it because these are some pretty inflammatory things that she was saying, and tensions were obviously really high in the wake of that attack. They did an investigation, which actually included interviews with some of the most senior level members of the firm. If you're a new attorney and you get called to the big office to talk with the senior members, it's either really good or it's really bad. So she ended up going to get interviewed. They ended up terminating her employment, and they cited a violation of their quote unquote core values without ever really clearly explaining to the court what the core values were that they say that she violated. And importantly, they had not disciplined any of the other individuals at the firm who had made pro-Israel posts. So you can kind of see that dichotomy there, where this individual who is Muslim speaking out against Israel, you have individuals who are pro-Israel speaking out against the terrorist attack, saying some pretty inflammatory things also, one could interpret them as, right? So there's a differentiation between how these individuals were being treated. And she sued them, and the law firm went on another summary judgment motion and said, court, please dismiss this because of all these undisputed facts that we have show that no religious or race discrimination occurred. The court denied that motion and refused to dismiss the case because it found so many material issues of fact about what that policy was, who was being disciplined, why they were being disciplined. Those are sort of the core issues in any discrimination case, is to remember, how are you treating people differently at the end of the day? And why are you treating them differently at the end of the day? Because remember, you treat people differently every single day. You just can't do it based on their protected category, like race, sexual orientation, disability. There's an intent element there. You can't treat people differently because of those reasons. The court said that there was too much dispute here to resolve that on summary judgment, and now it's going to be proceeding to a trial. So it was pretty notable because these were sophisticated parties, and the law firm is pretty big, and they've got the resources to throw at this, and it still did not get dismissed. So it was a helpful reminder on how to think about discipline, and are you treating people the same based on the same policy? Sometimes it's a common thing to say that this is the way that we've always done this as a policy or practice, that this has just always been how we do it. It's good to know, though, that courts are going to want to see documentary proof of what the policy is so that we can actually see how it is applied or supposed to be applied. It's easier to prove that rather than just a general statement about a practice at an organization. Because that was a key issue here, is what were the core values that were at issue? No one really seemed to know what those core values were, and that was the centerpiece of their case. So before you rely on a policy or practice to discipline or discharge someone, especially someone who went to Georgetown Law School, make sure that you have some facts in a row on it. Any questions? Okay. That's a really interesting one. Right, another FMLA case, and I'm going to get into a few statistics about employment discrimination later on in this presentation, but ADA cases are just like going through the roof, and FMLA cases are also on the rise too, just based on, COVID symptoms, medical conditions that people have, sort of awareness about diagnoses. That's why we're getting so many of these cases, it seems like. This one comes to us from Indiana, so we're taking a little trip out east. It involved a woman named Jennifer Shirk. who worked at Indiana University in its e-learning department. And I'll tell you why I'm laughing. She was fired 2 years after she was hired for sending emails to high-level university officials, needlessly, these are the court's words, needlessly alerting them to temporary problems in her unit and accusing her managers of mismanagement. So have you ever had an employee who goes over your head to your boss to like alert them about something that's happening that's really not your boss's like problem at this point? But the employee has chosen to escalate the situation to them? You can imagine the manager's reaction to all of this when this happened. So she was fired because she was not following the proper protocol in escalating problems with her employer. She had taken FMLA leave previously, though, to being fired and sued and alleged that her termination was not because she had gone over her manager's head. It was because she was taking FMLA and her request for accommodations related to her OCD and PTSD conditions that she had. Both very serious mental health conditions and would qualify for FMLA if she needed it. So whether she was entitled to FMLA was not the problem. It was what she did after she took it. And this is just a reminder too, a little bit about coaching your frontline supervisors on how to interact with especially difficult employees who always have something to say or always have a question or are really frustrating you for whatever reason. Just coaching them to maintain composure with them and to stay calm, because this employee pointed to a couple of statements that her managers had made in moments of frustration about the lack of notice that she was providing for her FMLA usage, and that her accommodations for her ADA conditions, her OCD, made it look like she was requesting a demotion. That's something that her manager said, is that, you know, you're requesting all these accommodations, doesn't that make it look like you're being demoted at the end of the day? What that employee heard is the word demotion. And if they're gonna take anything away out of that conversation, is that the word demotion was used in an ADA context with me. So it's no longer that the manager said, well, if you're asking us to take all these responsibilities that we had given you, doesn't that make your position look like a lower level position, a demotion? Perfectly innocent statement on its face. But what that employee heard was that I'm getting demoted and that these accommodations are a demotion to me. That's kind of the counseling that needs to happen on the front end with the managers and supervisors to maintain composure and not use those buzzwords that are going to be really loaded and are going to be the one thing out of a mountain of things that you discuss during a conversation that they take away from it. It's important too to remember that things will get said and taken out of context no matter how hard you try. Managers are not going to be perfect at this. They're not going to be able to say every correct thing at every left and right turn. And that's okay from a legal perspective sometimes, because isolated statements that a manager makes usually aren't enough to create liability unless they're like really clearly evidence of discrimination, right? So straight comments, isolated statements usually don't do enough. But just constantly managers about clearly messaging this to their subordinates and handling it with compassion is going to be a key thing, because this individual was struggling with OCD and PTSD, which may have played a role in how she was, understanding the information at the end of the day. So just kind of keeping track of those things is important to reduce legal risk and liability. All right, I think I have, one more case at this point to talk to you about. That's another FMLA case. I'm sorry, this is FMLA heavy, but these are the newest cases that have come out. All right. Oops. All right. This case arose out of the city of Chicago, and the plaintiff, I don't know if I'm going to pronounce that, Patarakos. I'm going to do my best. Plaintiff's name was Stella Patarakos. She was a white woman, and she got a new supervisor named Crystal Warren, who is Black. After Warren was assigned to supervise Patarakos, she began issuing discipline against Patarakos for the first time in Patarakos' career. including 3 suspensions, a transfer to a new location temporarily, and supervisor was citing multiple performance deficiencies, which when Ms. Paterakos was confronted with those things, she didn't actually dispute them. She agreed basically with the performance deficiencies that she had. But at the end of the day, she said that she wasn't being disciplined because of those things. The real reason was race discrimination and FMLA retaliation and interference. The court looked at all the evidence, ended up rejecting the claims and ruled in favor of the employer. And why I chose this case as an example is because the clear documentation in the case was really helpful. To sit down with that employee to document the specific reasons that are being cited for your discipline, especially when you're on an FMLA leave of absence. You want to have very clear record moving forward about the reasons so that there isn't a factual dispute about what reason is being given for the discipline. So, you know, it's also important to remember that not everything that an employee doesn't like in the workplace is going to be actionable. I think I presented to you on a case a year or two ago that loosened the standard that plaintiffs have to meet to prove an adverse employment action. That was a big red flag to a lot of defense attorneys like me, because it made it easier for plaintiffs to point to things that they didn't like in the workplace to qualify as an adverse employment action. This case assessed that case and lowered the threshold and said that, yeah, even though the Supreme Court said that it's a lower bar, you still have to show some kind of harm at the end of the day that you're suffering. Just saying that you don't like your hours being changed or being transferred temporarily to a different location, those could qualify as an adverse employment action if it harms you in some way, but just citing them without some backup rationale for why that's damaging you, that's not gonna cut the mustard. So just being cognizant of the reasons given for discipline and transfer and changes in employment status are important going forward. Any questions so far? That time, I don't have to watch, I'm sorry.
20 minutes.
20 minutes, all right, cool. Trends and refreshers, all right. I like this section because it's a little bit on what I'm seeing day to day in my employment law practice, and I hope it will be helpful for you. This is what I was talking about a minute ago, record lawsuit filings, what we all like to hear. According to a legal research engine, over 20,000 employment discrimination lawsuits were filed in 2025, which is the first time since 2009 that we've crossed that threshold. That's a lot of lawsuits. That's a lot of disputes out there about employment discrimination. Specifically, employment lawsuits alleging a failure to provide reasonable accommodation also surged to a record number in 2025. It's almost 7,000. So we're pushing 7,000 there. That's a lot. The research engine that I read, the report that I read, attributed that increased number to higher damages awards. So plaintiffs receiving huge amounts of money for alleging employment discrimination, an ADA, failure to accommodate, and also conditions such as long COVID, which we're just now starting to see a little bit more clearly. So employees who are struggling with loss of taste, fatigue, all those different weird symptoms that are associated with long COVID, employees are requesting accommodations for that and saying that their employers haven't been accommodating them. So that's just a little bit of an interesting tidbit that I wanted to share with what's happening out there. It's raining out there, so. Right, we covered this a little bit, but we'll circle back to it briefly. So even if you're not FMLA covered, remember that leave can sometimes be required as an accommodation, even if you are not covered by the FMLA. If that condition qualifies as a disability, you are at least required to explore whether a short, definite leave of absence can qualify as a reasonable accommodation for that employee. The way I like to explain it is the FMLA is about getting people out of work. That's about keeping them out. The ADA is about getting people back in. So the leave of absence has to be finite. You have to know when that employee is going to be back in the office to have that qualify as a reasonable accommodation. An indefinite leave of absence will never qualify as a reasonable accommodation. So for example, an employee hands you a doctor's note and says they'll be reevaluated in 6 months and maybe they'll be able to return them at that time. No, not a reasonable accommodation for leave at that point. You don't have a definitive end date for that employee to come back. If the employee also, and I've had this happen, gives me heartburn, they submit doctor's note after doctor's note after doctor's note, extending their leave 2 weeks, 3 weeks, a month. And it just keeps happening as a pattern. After the first few times of that happening, I start to say, this is turning into an indefinite leave of absence and we don't know when that person's actually going to be coming back. So the duty to continue that leave is likely no longer required under disability law. So.
Can you speak to an
Yeah.
intermittent leave as an accommodation? How do you manage that?
Yeah, so,
Like if someone is exhausted FMLA and their accommodation request is intermittent leave.
so the ADA contemplates that a reduced work schedule could be a form of a reasonable accommodation. So if they're scheduled to work 40 hours and the doctor thinks that they can only work 35 hours, then that's something that they can potentially require. Also, if they need to take a couple of hours a day, if they have like migraine headaches or something like that, or some sort of mental condition that they need to take periodic breaks, that's a form of intermittent leave and has to be at least considered.
Would it need to be very prescriptive in the determination form that's provided under the accommodation request? Or like when you utilize FMLA, you can call in and say, you know, taking an FMLA day, right? How do you manage that piece? Or how do you, does it have to be that descriptive of like, you're gonna work less hours or you're gonna leave early, but if you have a headache, you don't know.
Yeah, I call them dear doctor letters because that's how I start the letter. And I tell the client, like, time for a dear doctor, let's do this. Where I ask them, like, usually between like 8 and 15 questions that are targeted to pin that healthcare provider down as much as they're still gonna like say the most employee friendly thing they can and give you kind of vague, wishy-washy answers. But what I do is I target the questions specifically to what that employee situation is. And I say, how long in advance does this employee know that they will need a leave of absence? How many days per week? What are the duration? Is there any other accommodation besides an intermittent leave of absence that I can consider offering to this individual? Those sorts of things can depend upon what the situation is, but you can definitely tailor those letters to get what you need.
Is there a risk or liability in allowing for the extension and the extension and the extension? If you can accommodate it as a business, is there a risk there? Is it okay to be flexible allowing that way?
Yeah, the risk that I see most frequently is that if you keep extending the leave and you're not staying on, and like, again, a couple of extensions is most likely gonna be okay and not lead to liability. But the more that you're prolonging that leave of absence, at what point do you then say it's become an undue hardship? Was it the first time, second time, fourth time, fifth time? So just making sure that whatever leave of absence you're granting, you're staying on top of it and not just signing off every time they send a doctor's note to you, because it'll be harder to prove hardship in the future.
So can I repeat it back to you to be sure I
Yep.
understand? So at a certain point, if you keep being just very allowing, there becomes a lack of clarity around why you end it and call it an undue hardship at a certain point, and that is where the risk comes.
Yes, and again, when you approve a leave of absence as an accommodation, you should repeat it back to them in writing and say that here's when we expect you back to work. Give them that date. So that if they try to send you another letter, you at least consider it. But if you really need them back, if they're a key employee, easier time to prove hardship and not allow it. Makes sense? Okay. Did you have a question?
I did,
Yeah.
and it's a segue actually into that, at what point of the intermittent leave or accommodation turns into undue hardship? Can you give examples?
Yeah, and I always ask that to the employer. So I'm like, okay, what is your business? What is the, and if I know you, I'm usually familiar enough with what's going on. Who is this employee? What do they do for you? How long have they been out on leave? What have the doctor's notes said? And why do you need them back now? If it's like a time-sensitive customer-facing position or something like that, usually probably a little bit easier to show undue hardship because there's a business need there. But yeah, as it relates to when it becomes a hardship, that's usually you start hearing from your frontline managers first. It's like, this person isn't here, the workload is not getting done, everyone's stressed out. Those are things that you can take into consideration. Yeah.
What if, let's say you have an employee that has been working for quite a long time, for example, 30 years, and they all of a sudden are requesting for 88? Is there like a, I don't know if it's the right word to use, but like a silent rule where like employees, that employees are required to follow their accommodation just because they have been with the employee?
So for the same, if they've offered it to the employee in the past, then they have to offer it in the future.
And it's like an implied accommodation because you accommodated for so long.
Yeah, so if you're doing it for other employees, you're likely gonna want to at least explore it with this individual. Again, employees are different with different job roles, responsibilities. So you can take an individualized assessment with what that individual's needs are and what the business's needs are and try and tailor it. But I guess I would hesitate a little bit to offer an implied accommodation or an implied policy. You're gonna wanna have something in writing that explains what the process is and what the employee's expectations should be. So, yeah.
So your first slide was on travel, paying travel, or not paying travel time, but FMLA for travel time for, appointments.
Mhm.
Something that is tricky is behavioral health.
Mhm.
And plenty of employees go to therapy, some use sick, some use PTO, you never know. But if you have an employee that's requesting FMLA
Mhm.
for a behavioral health condition, just, and their physician form is just appointments, just to get to appointments. At what point would you consider, like, is behavioral health always FMLA, or at what point is this something that the average person is doing and not requesting FMLA for?
Yeah, so the certification form will usually key you in on who the healthcare provider is, where they're located, how long that travel time is gonna be. I hesitate to give a blanket rule, since the famous lawyer answer, it depends. What the condition is, what this individual is asking for. So if I understand the situation, if it's a behavioral health, like, OCD or something that they need to go to a therapist for once or twice a week or a monthly or whatever the certification is, then yes, that will qualify as an FMLA condition and that travel time would qualify also. But remember that the certification doesn't have to include the amount of travel time for it to be valid. So just because you can't determine how long it's gonna take them to get to appointments, doesn't mean that that certification is invalid. But that employee is gonna be leaving, 30 to 45 minutes if it's a distance away ahead of time. They'll tell you, or at least they should be telling you that I gotta leave at 12:30, my appointment's at 1:15 in Toma, or whatever, right? So. Does that answer your question?
Yeah.
If it did, I'm happy to take another step.
Well, yes and no, so. I think it's tricky, is there's so many people with, varying degrees of behavioral health needs.
Mhm.
And at what point do you tip the lever into FMLA territory when the only thing you're requesting it for is to get to a therapy appointment and nothing else?
Well, I think that therapy appointment would be FMLA covered, yeah. So,
They have to initiate that?
well, if it's a
employee?
condition, the employee will have to give you sufficient information to let you know it's FMLA covered.
Right.
So I think I see what you're saying now. So how do you know when the condition is an FMLA qualifying condition that you need to start the process with to get them into it?
Yeah, there's like an employee that
Yeah.
goes to therapy, but they just take their PTO, like so
Oh.
many people feel varying
I see.
degrees of severity, so like,
Yeah, and you
at
can,
what point do you tell, if I know Sarah, for example, is she's taking PTO to go to therapy twice a month, but then Megan requests FMLA to do it once a week.
Mhm.
I don't feel like I'm treating them fairly, but do you open the can of worms and tell all employees, like, if you're going to therapy, which 70% of you probably are, come talk to me about it.
Or should
Or,
be.
at what point do you, does it become like,
You're gonna be busy.
yeah.
It's for, if they wanted to, it's usually in their interest to come to you to have it be FMLA so that it's protected. Because if they're just under their PTO policy, you don't have to approve that, it's
Yeah.
in your discretion. So if it becomes like, and here's how that would probably play out. They're not abusing, but they're taking all of this PTO time. And it becomes unwieldy for, the employer to handle that. And you're thinking, this is an excessive use of PTO. I'm not gonna let you use that. You run the risk though, if you know that that condition that they're going to therapy for is an FMLA qualifying condition and you didn't sort of initiate that process with them, just give them the paperwork to say, here's what I understand you to be saying is that this might be an FMLA qualifying event. You are eligible, have this certification filled out so that your job is protected every time you are going to therapy to have that time set aside for you. Because if you're just under PTO, it's not necessarily going to be protected in the same way. And sometimes employees get weird about wanting to request FMLA. I don't know why, like if they're afraid of it or whatnot. So just messaging about it, that it's for their benefit to have that in there so that it's job friendly.
You ask, oh, tell me more, and I tell you like, oh, I have anxiety, and then the other gives you like their life story in an email, and so you don't wanna.
Yeah.
Like, here's a fine line of just getting enough information about the ambiguous provider certification
Yep.
to get them to where they need to be.
When you get that life story in an email, and those drive me crazy, you respond back and say, what I understand you to be telling me is this. If you would like to take FMLA for this, you have these many hours left. If you use the calendar year, rolling year, whatever, look to see if they're eligible, how much time they have. And then start that process with them and explain to them that if they don't start that process, it's not protected leave. And that'll usually get them there. And the employer can also just unilaterally designate too if they want to, but.
Yeah.
All right, great questions. I've got 5 minutes left. And yeah, why don't we do a hypothetical scenario, take a couple minutes, and then we'll talk about what we think. So Marcia is a long-term employee who is nearing retirement. She lost her husband last year and hasn't been the same at work ever since. She applied for FMLA and was approved for intermittent leave to seek counseling for depression. Her sessions happen several times a month for a few hours at a time. You've been tracking her FMLA diligently, good for you, and you've been good about notifying me when she has counseling sessions. That never happened. So this is like best case scenario. However, her FMLA expired last month, and you've noticed that she's been leaving work early and going missing throughout the day for 30 to 60 minutes at a time. Marcia's manager came to you to report she seems off and uninterested in work. What do you do now that her FMLA is expired? So we're out of FMLA land. What do you do? Take a couple minutes, you talk to your folks at your table.
Diet Coke break.
I kind of immediately goes to my, and I just have a conversation about older two meetings and I especially since we know that we've already been speaking, professional assistance or something. And I'm really sad. Really sad. You know, and then I'm like, I think here.
Appreciate it.
It's exhausted, you know.
Oh, it's that? Yeah.
We're really expired.
Well, it's fired.
That's
Yeah.
different than exhausted. How many of us are like, look exhausted? No, it's not. If it were exhausted, then I feel like it would be 88. Well,
Well, how about my question?
what was it again? Yeah.
Employee relations conference, so I made a recommendation, so I made a recommendation, it doesn't work in my facility. So he's coming back to find out.
that was right to an accommodation.
Anybody have thoughts at their table if they're willing to share?
And so what can we take away?
So the first thing we've done is to have a conversation with Marcia, especially if the managers come to you and say that she's seeing a little off, to have that conversation with her proactively, which I like, to just sit her down in a private space with, just the two of you in a secluded area and just say, how are things going? Are you doing okay? And then if she opens up, great. If she doesn't, then you can bring up the things about the 30 to 60 minutes that she's going missing throughout the day. What are you doing? How can the company support you? What can we do to help you? Start that interactive process. I like that. Yep.
We were just debating over here because in your scenario, you said her FMLA hours have expired versus exhausted. So theoretically, could she just recertify?
That's
For
great.
attention.
And did you go to law school?
No.
I meant to say exhausted.
Her mind went to, but she caught it.
Good.
So that is a great distinction. Yes. So hours have expired, get recertified, or, whatever new condition may be, but assume that they are.
Yeah.
Out of luck. Anybody? Someone wants to make me look good, please.
How does the company determine if they should do a calendar year or rolling?
Yeah, we have clients who do both. I mean, it's sort of just business dependent. The key is that if you want to switch between the calendar and rolling year, whatever you want to do, to give that 60 days of notice to employees if you're going to be changing the calendar. So sometimes, say, for example, a manufacturing client wants to just run on the calendar in year because that works better for them. And remember too, you have a choice with federal. You do not have a choice with state. Wisconsin FMLA only runs on the calendar year. FMLA at the federal level, you have your choice. Most people like to use the rolling back calendar because that's typically seen as the most employer friendly. But you can beat, some clients like to just have it run both. Wisconsin says only calendar, so we'll do federal that way. The risk you run though, if you do the calendar year, is that say that Becky goes out, takes time to give birth in October 1 of 2026, so this year. If she has her 12 weeks of leave through the end of the year, starting 1/1 of 27, she re-ups on her calendar year of FMLA. So thinking about strategically, if you want to prevent individuals from stacking their leave to extend their leave for a huge amount of time, thinking about using a rolling back or a calendar year, sort of dependent and up to you. So those are sort of the risks. We're right at 1 o'clock. I had more material, but we're not going to get to it because I want to get you guys back. But it's always a pleasure to be back. I love this group. Thanks for having me back. Really appreciate it. Take this up at the table, chip clips, articles up here. If you want to sign up, but great to see you all.
Thank you. We're not. Yeah, you can call your comfort. You get two more.
Okay, can I switch over and then do our book drawing?
I know.
But online.
It's nice.
Take it back with
It
us.
was the, SHRM,
We'll take it back with us.
okay.
Yep.
What we have to do. We will ship it.
But that's just Amanda.
We will ship it. Thank you, Storm. Thank you, everyone who came in person, online. Great to see so many of our members engaging this topic that obviously we interact with a lot. So have a great day and, enjoy the rest of your week. Thank you.
I was like, I had you like, after order one, okay.
Yep, we'll order it and ship it.
Hey, Jen.
Yes, take care.
I haven't talked to you yet today.